Okay, we're going to go ahead and get started. Good afternoon, and thank you for joining us. My name is Tracy Thomas Card, and I'm the Advocate Support and Grant Manager at Standpoint. My role today is to help facilitate this webinar. So if you have questions during the presentation, please go ahead and type your question in the Q&A tab, and we'll pass that along. Most of you probably know about our organization already, but for those that listen to this later and those that don't know, Standpoint is a statewide organization. We're a team of attorneys and advocates working to assist individuals who've experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our toll-free action line. Examples of trainings that we do are the annual New Laws training throughout the state of Minnesota, monthly webinars for advocates, and other trainings upon request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. And it's through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety planning, listening, and helping callers identify possible options and next steps. This webinar is being recorded, and you can check it out on Standpoint's YouTube page. The link to the recording will also be emailed out to Standpoint's Legal Advocates listserv after the webinar. Now to introduce the webinar and panelists. Today's webinar is focused on eviction expungement. Our panelists are Anne, our housing grant attorney, and Raelene, our housing advocate. Anne joined Standpoint in March of 2020. She is a graduate of Mitchell-Hamline School of Law and has focused her legal work on housing law, landlords, and tenants. Anne has experience in providing legal services to underrepresented individuals, providing advocacy to victims of sexual violence, and training and supporting volunteer attorneys doing housing work. As a housing attorney for Standpoint, Anne provides legal advice and consultation on legal issues affecting victims of domestic and sexual violence. Anne received her JD from Mitchell-Hamline School of Law in 2017 and her bachelor's degree from Metropolitan State University in 2011. She is a volunteer crisis counselor for Ramsey County Sexual Offense Services and volunteers at the Comunidades Latinas Unidas and Servicio Cruz Legal Clinic. Raelene began her work as an advocate in 2009. Her work in domestic and sexual violence has focused on crisis intervention, case management, shelter work, hospital-based advocacy, program development, and the wellness and resiliency of advocates in the field. Raelene has provided housing assistance and systems navigation within the coordinated entry system, rental assistance, and building relationships with landlords. She's excited to build upon this work as the housing advocate and to provide education and training on housing rights, coordinating eviction expungement clinics, and developing resources for safe and stable housing options for families and youth experiencing homelessness due to domestic or sexual violence or trafficking. She graduated from Gustavus Adolphus College, majoring in gender, women, and sexuality studies and history, and holds a master's in advocacy and political leadership from Metropolitan State University. Without further ado, I'm going to turn it over to Anne and Raelene.
All right, welcome everyone. Thank you so much for being with us today. Thanks to Tracy for giving us that great intro. We're glad that you're all here with us. So to get the day started, we are going to be talking about eviction expungements. And so we'll just kind of jump right in. And I don't know, did you want to say hi before we get going?
Sorry, I wasn't ready for that. Hi, everybody. We're glad you're here. Hopefully, we can get through this webinar on eviction expungement, and you guys will learn a lot from it. If you have questions, again, feel free to ask at any time, and we'll do our best to answer.
Absolutely. Perfect. Thanks, Anne. Sorry for the surprise. All right. So Tracy kind of gave a good overview of who Standpoint is and what we do. But just for some additional background information, we are formerly known as the Battered Women's Legal Advocacy Project. We changed our name to acknowledge that violence happens to all genders, expressions, and identities, and to be more inclusive and intersectional in our language. We have attorneys and advocates that work in lots of different areas of law and advocacy work. And we are a statewide organization that provides services to victim survivors of domestic and sexual assault. And for folks that are accessing our services, it is free regardless of your income, and there's no intake required. So that's some background information on Standpoint in addition to what Tracy has shared with us. our agenda for the day, kind of our roadmap, is we'll start by talking about what is expungement. What does expungement look like, and who qualifies? What makes for a good case for someone to file for an eviction expungement? And then Anne will get into the big picture of what eviction expungement looks like and talking about the law behind the expungement process. Then we'll talk a little bit about drafting the motion and the eviction expungement process as a whole. And I think that I'm really glad that you're all here with us today, because we think that advocates can really have a good role in helping folks through this process, because we know that lots of people are facing eviction expungement or have evictions on their record, and we want advocates to be more involved and be more prepared to be involved in these processes going forward. So the first thing that we'll start with is why eviction expungement? And with COVID, it has brought many changes to our work in so many ways, and that includes housing. You know, there have been eviction moratoriums, both federally and on the state level, and people aren't being evicted at this time for lots of different reasons. However, you know, while we do have the eviction moratorium at present, that's not going to last forever. We don't know when that will change, but definitely take a look at our housing newsletter for more and updated information on that. But we want to think about what's going to happen when the moratorium is lifted. So we want folks to be able to move through the eviction expungement process, whether that's something that happened because of COVID or prior to COVID. And we also think that advocates are a great way for people to move through that eviction expungement process. So long story short, we know that housing is about safety. An eviction record is a barrier for people when they're trying to find new housing or when they're trying to leave housing that's not safe. Landlords see that eviction on the record and they're not excited about it. So if we're able to expunge it, that opens up new options for people. We know that lots of tenants and victim survivors that we're working with have evictions on their record and they don't even know. A lot of people think that the eviction is when you actually have to leave a home that you live in, but that's not true. It actually goes on the tenant's record the date the case is filed. And that could remain on their record, even if there was a settlement, things like that. So lots of people have evictions on their record that they don't even know about, and that can provide barriers to finding future housing. And that eviction record also limits access to safe and stable housing and can often lead to long-term homelessness. We know that lots of folks that are experiencing homelessness are homeless due to domestic or sexual violence, and it can lead to insecurities in housing and safety. So with that, excuse me, what would make for a good case for an eviction expungement? Which evictions qualify? And you know, the best answer, as an advocate would always say, or an attorney would always say, it depends. In this case, it depends on the court or the county and the judge. There are a few factors that the court can consider when thinking about eviction expungement. And the first one is why that eviction occurred. So did the eviction happen because of non-payment of rent? Maybe the person that was living in the home had a financial hardship, lost their job, or COVID hit, for example, and everything kind of got upended. So what was the situation surrounding that eviction? Was there a material breach of the lease? And with that, is there a reasonable explanation for what happened? So kind of telling the story of what happened with that eviction. The courts will also look at how much time has passed. So if this is a really old eviction from 7 years ago or something like that, that would be a good option to look into eviction expungement. If it's something that happened a week ago, I don't know, definitely you can talk with Anne more about that, but the older evictions usually provide more opportunity for expungement. A huge one that can often be a barrier is whether or not money is still owed. There are some counties that if you owe money to a previous landlord, they're not going to be looking at expungement. So sometimes that can be a barrier to filing for eviction expungement, but in some counties it's not a barrier. So you kind of have to know what's going on in your area, and you can kind of find out more information there to see if it's helpful. And then there are other evictions. Are there other evictions with the same landlord? So did the same landlord file multiple evictions back to back every month when someone was late? Are there other evictions from other landlords that person has on their record as well? So all of these are different considerations to take into account when thinking about eviction expungement. And as always, I think that when you're working with someone, you can always reach out to Anne to kind of talk this through and see if this would be a good fit, or if the timing is right for eviction expungement, and if the person would qualify.
just like so many of you out there help clients draft protective orders and help clients with other court forms, we believe that you can help people write expungement motions. So the goal of the webinar here is to give you enough information so that you'll feel comfortable helping the people you work with write an eviction expungement motion. In the very least, we hope you take away from the training that the process is not extremely complicated and that you're able to help people through it. And of course, we're always here to provide whatever help or support you might need with the process. Before we jump into the legal details of eviction expungement, I want us to take a step back and think about the main idea of what needs to be explained in an eviction expungement motion. As you'll learn here today, there are a few different legal bases for eviction expungement, but in most cases, the details that are required to prove the legal elements needed for expungement actually boil down to what I think of as the big picture, which is really the story we want to tell in our expungement motions. The big picture can be broken down into three main parts. First, we need to explain why does the tenant need this expungement. Then we want to explain what was happening at the time of the eviction that caused the eviction to occur. And finally, we want to detail how has the tenant's life or situation changed to make them a safe person to rent to from the perspective of a future landlord. When we focus on answering these three questions, in most cases, we will have a solid eviction expungement motion. One key thing to see here is that when we're writing our big picture, it's important to make sure that number 2 and number 3 go together. So in number 2, when we're explaining what happened at the time of the eviction, like what happened that caused the eviction, we need to address those things in number 3 by explaining what is different now so those things won't happen again. So as we move through the legal details and the process for eviction expungement, let's keep these 3 parts of the big picture in mind. And if there's one key thing I want you to take away from this training, it's not to remember all the legal details and the different legal arguments about eviction expungement. It's to remember to tell that big picture. So moving on to the legal details of eviction expungement, there are 3 types of eviction expungement: inherent authority, statutory discretionary authority, and mandatory expungement. Inherent authority is the most common type of eviction expungement, and it applies to almost all eviction cases. Discretionary, statutory discretionary expungement, it's somewhat common, but it doesn't necessarily apply every time. And mandatory expungements are much less common. They come up only when the eviction was the result of a mortgage foreclosure or a contract for deed cancellation. We want you to be sure to always use an inherent authority argument in our expungement motions. And then when there are legal issues with the underlying case, which we would include, then we would add on a statutory discretionary argument in addition to that inherent authority argument. So for this training, we're going to focus heavily on the inherent authority argument. And that's because, like I said, we argue inherent authority with almost every eviction case, expungement case. And when we start out with writing a strong inherent authority argument, we can refer back to it for cases where we add the discretionary authority argument so that we're not duplicating our work. So one way the court gets its authority to expunge eviction records is from case law, and this is what we refer to as the inherent authority argument for expungement. The specific legal elements needed to convince a court to expunge an eviction come from a couple of different cases, and they are: first, that the expungement is necessary to the performance of a judicial function and necessary for justice; that the expungement will yield a benefit to the petitioner, who is the tenant, that is equal to or greater than the disadvantages to the public from elimination of that record. And the third element here is that expungement will yield a benefit to the petitioner that's equal to or greater than the burden on the court in issuing, enforcing, and monitoring an expungement order. When the tenant can prove these 3 elements, The court then uses its discretion to decide if the case should be expunged. So it's still up to the judge, it's not mandatory. Generally speaking, a good eviction expungement motion form will have all this legal jargon that's needed for the motion already in it, and then allow space for the tenant to fill in the form with specific facts and details of their situation. We here at Standpoint have created what we believe to be a fairly user-friendly eviction expungement motion form, which you can contact us and get. If it's not already available on our website, it will be very soon. The crux of the argument that we make in expungement motions deals mostly with the second argument here. So we're going to look closely at that and see how it fits with our big picture framework. So let's break it down. When we're thinking about this phrase, expungement will yield a benefit to the petitioner that's equal to or greater than the disadvantage to the public from elimination of the record. We basically want to write the tenant's story in a way that shows the benefits to the tenant of expungement are substantial, they're high, and the harm to the public that might result from expunging the eviction is low or minimal. So now we're gonna break that down and talk about each part separately. We can go to the next slide, Raelene. Thanks. So to show the substantial benefit to the tenant in granting the expungement, we want to state two things. We first want to explain how or why the expungement will benefit the tenant. This one might seem obvious. In fact, it is obvious because we all know having an eviction record is an obstacle to obtaining safe and stable housing, but we still have to write it out. Next, as a part of this substantial benefit piece, we must state that the eviction record is a burden. This is really important. Explaining how the record is a burden is a must for this part of showing the substantial benefit. So we think back to the first element of our big picture, that why does the tenant need this expungement? The substantial benefit part of the inherent authority argument, it goes along with that first element in our big picture. Why does the tenant need this eviction? Because the tenant needs to find housing and the eviction record is causing problems for the tenant. So next we'll look at an example. Here's an example of the first element of our big picture, that question, why does the tenant need this expungement? Which again, goes along with the substantial benefit part of an inherent authority argument. Again, some of this is going to seem obvious or redundant, but we still it needs to be a part of the motion. So let's look at that first sentence. The benefit to Mr. Smith in granting this expungement is substantial and far greater than the disadvantages to the public from elimination of this record. You can go ahead and use this language. In every expungement motion I write, I use this sentence. The next two sentences will explain why the tenant needs the expungement, which supports that substantial benefit part of the inherent authority argument. Expunging this eviction record will benefit Mr. Smith by removing a significant barrier to his ability to obtain safe and stable housing. Mr. Smith is a single father of 2 children and they are currently homeless. Again, the sentence here about removing a barrier to obtaining safe and stable housing is one you can use, and it's one that I use in almost all the expungement motions that I write. The other details that you include in this section may vary widely depending on the situation that the tenant is in. And I definitely use all that I can to show why granting this expungement right now is especially important. So if there are other hardships that the tenant is facing because of this eviction, then we want to consider writing about them. One thing I can think of right now, especially, is that all of these issues with homelessness and finding safe and stable housing, it's all just amplified. It's more important. It's harder right now because of COVID, because being in shelter or moving around a lot, is not necessarily safe when we think about, protecting ourselves and our families from COVID. So right now I would include something here about that in a motion. So lastly here, we need to state the burden. He has been denied housing because of his eviction record. Depending on the situation, the tenant may have more than one burden to list here, but one should be enough. So like what was noticed on the previous slide, there might be other ways that the eviction record is a burden to the tenant, such as needing a co-signer or needing a co-tenant, or being forced to live in substandard housing, and sometimes just chronic homelessness. Again, the burden piece seems obvious, but it needs to be stated. I've seen eviction expungement motions denied that were otherwise qualified, right? That otherwise would have been granted, but no burden was stated. And that makes sense from the court's perspective, because no one should really be using the court's resources by filing motions when they don't actually need that relief. So it's important that you definitely say this eviction is causing a problem, and then say how. The next part of the inherent authority argument is to convince the court that the public will not be harmed by removing the eviction record. When we think about eviction records, it's important to remember that it's really just another court record. And as a matter of public policy, mostly all court records are kept and available to the public. Part of that has to do with transparency in our court system. One rationale for eviction records being kept available to the public is that future landlords may need to be warned or protected from renters with poor rental histories. So for this part of the argument, we need to convince the court that the public, think future landlords, do not need to be warned about this particular tenant. So to do this, I try to show the court that the eviction record does not give the public an accurate impression of who the tenant is and what kind of renter the tenant can be today. I support this by stating that the record doesn't reflect the current situation, and I explain two things. I explain what was happening at the time of the eviction to say what led up to the eviction, and I explain how the tenant's situation has changed that makes them a safe person to rent to, again, from that perspective of future landlords. Hopefully you caught that these two things align with our big picture elements, number 2 and 3. So some examples in my experience that I have seen of things that were happening that led to the eviction or that caused the eviction is, the tenant lost their job or had their hours reduced. The tenant missed work because their child was sick. Both of those things can lead to this spiral of falling behind in bills and then eventually falling behind in rent, so much that they end up being evicted because of non-payment of rent. I've seen where the tenant was in domestic violence situations that resulted in an eviction, maybe because their ex controlled their money, or they ended up just being evicted because of too much going on the property. I have worked with a tenant who had a death in the family and they had to use their rent money to pay for the funeral. And then again, that kind of starts that spiral effect of falling behind on bills and rent that can often lead to eviction. We know that nearly 95% of the evictions in Minnesota are for non-payment of rent. And we know that lower income people are particularly susceptible to being evicted after some seemingly minor events occur, like missing a few days of work or having a child get the flu. Even though these might not seem like big things, for something to be writing about in a court motion, these are all valid events for explaining why the eviction occurred, and we should include them. So here is an example of our big picture number 2. The first sentence clearly states, the disadvantage to the public from the elimination of this eviction record is minimal and does not outweigh the benefit of expungement. This record does not provide the public with an accurate impression of Mr. Smith's current situation and his ability to be a good renter. Again, I use a version of this sentence in almost all the expungement motions I write. This uses the exact language from the elements that we pulled from case law that we talked about a few slides ago. The next 2 sentences explain what was happening at the time of the eviction. So I say, at the time of the eviction, Mr. Smith had unexpectedly lost his job, which resulted in him falling behind on his rent. At the hearing for this eviction, Mr. Smith and the plaintiff, or the landlord, entered into a settlement agreement, and Mr. Smith complied with the terms of that settlement agreement. So together, these 2 sentences, or these 3 sentences, address the first part of the minimal harm argument for inherent authority eviction expungement. And again, this is the one place where the details will vary widely depending on the facts of the particular tenant's story. And here's an example of our big picture number 3, where we explain what's changed since the eviction. And we try to convince the court that the public does not need to be protected with regard to this tenant. Since the eviction occurred, Mr. Smith has worked with a Dakota County housing advocate, secured Section 8 housing benefits, and maintained steady employment. After his experience with homelessness and facing the challenge of obtaining housing with an eviction record, he understands the importance of maintaining a positive relationship with landlords. Additionally, he knows to seek assistance sooner rather than later if he's in a situation where he might fall behind on rent. So I hope you can see here that the previous section, our big picture number 2, we stated the eviction occurred because Mr. Smith had lost his job, so he fell behind on rent. So basically the eviction was caused by the financial uncertainty. So in this section, our big picture number 3, we address how Mr. Smith's situation has changed and the steps that he's taken to ensure that his rent will be paid going forward, even if there is more financial uncertainty. And again, just to restate it, our big picture 2 and 3 address the minimal harm part of the inherent authority argument for eviction expungement. So let's look at our big picture framework along with the inherent authority argument for eviction expungement. We have the 3 parts to our big picture. Why does the tenant need the expungement? What was happening at the time of the eviction? And how has the tenant's situation changed to make them a safe person to rent to from the landlord's perspective? And then we have the main narrative part in the inherent authority argument for eviction expungement, and where it says expungement will yield a benefit to the petitioner, that's the tenant, that is equal to or greater than the disadvantages to the public from elimination of the record. So hopefully this visual helps you see how these things go together. And that pretty much covers how we write and how we address the written story part of an eviction expungement motion. As I mentioned, the other 2 parts of the inherent authority argument need to be addressed, but those parts do not typically include all the different details of the tenant's story. And a good motion form is going to have that language in it already for those parts so that you don't have to worry about writing them. And again, another plug, we have created a motion form that has all this language in there that we think is pretty user-friendly that we can help you with if you want to start helping people with eviction expungement. So that is the main big picture part for inherent authority eviction expungement. And again, if there are any questions or anything we need clarifying, feel free to throw them in the chat. We do still need to talk a little bit about that 3rd part of the legal argument for inherent authority. And this is that expungement will yield a benefit to the petitioner that's equal to or greater than the burden on the court in issuing, enforcing, and monitoring an expungement order. Since we've already explained the benefit to the petitioner, we don't need to start from scratch. We don't restate that benefit. For this part, what we really do is we typically refer to the court's record retention schedule. And the court's record retention schedule provides that eviction records can be destroyed either when no money judgment was ordered in the case and the case was closed over a year ago, or where there's a money judgment ordered, the ordered amount has been paid in full and the case is over 10 years old. So the argument here is to say, this is not a burden on the court to expunge this record because the court's own record retention schedule says you can expunge this record. The thing about that is that the retention schedule doesn't always fit with all the different cases. When it fits, we use it, and when it doesn't, we still have an argument to make. It's important to realize here that, again, most eviction cases are for non-payment of rent. And most of those cases end with a settlement agreement or a payment plan. In these cases, even though money is a part of that settlement, usually, that does not mean there's a money judgment ordered in the case. When a money judgment is ordered in a case, there will usually be an entry on the docket in the court case file that says judgment docketed or money judgment docketed or something similar to that. If you see that language on the court docket or in the case file, Give us a call and talk about it. Even in these cases where there's a money judgment ordered and docketed and less than 10 years have passed, the court might expunge something, you know, if the tenant has repaid the landlord or worked out into another agreement with the landlord, and if the landlord does not object to the expungement. So even if it doesn't, you know, the case doesn't quite fit into the court's record retention schedule, you know, you can give us a call. We can talk about that. And I think, you know, that we can still figure out how to make that happen. And again, the language for this part of the inherent authority argument should already be written in a motion form. So you shouldn't have to make this language up. You know, the form will just have the language and have check boxes you know, for the tenant to choose which situation fits. So that's it for inherent authority expungement. And again, we use that every time. We're going to look now at discretionary expungement. And again, discretionary expungement is something that might be added to an inherent authority argument, but it doesn't apply to every case. Minnesota statutes allow for courts to expunge court records when the underlying case or the plaintiff's case is sufficiently without basis in fact or law, which may include lack of jurisdiction over the case, when expungement is clearly in the interest of justice and the interests of justice are not outweighed by the public's interest in knowing about the record. Like with inherent authority, when a tenant can prove these three elements, the court then uses its discretion to decide if the case should be expunged. So it's still up to the judge. It's not mandatory. The first element we use for statutory discretionary expungement is that the original eviction case was sufficiently without basis in fact or law. This means to have a statutory discretionary expungement argument, something had to have been wrong with the landlord's case, with the original eviction case. So we look to defenses to an eviction action to determine whether the underlying case, you know, had some errors, whether it was sufficiently without basis in fact or law. There are some obvious problems to the original eviction case that you might easily recognize, like the tenant had moved out of the property before the eviction, or maybe the tenant never lived at that property. You know, that's an obvious flaw, an obvious issue with that underlying eviction case. Maybe the tenant had terminated their lease early due to domestic violence before that eviction was filed. You know, maybe the landlord withdrew the case or did not appear at the eviction hearing. For cases based on non-payment of rent, maybe the property had pest or repair issues, or maybe the rent had been paid in full by the time the case began. All of those are some kind of obvious issues that you might spot, but just know these are just a few possibilities, and in the law, there are many, many other potential issues that could be there with that underlying case. So this is where, if you're helping someone with an eviction expungement, you might benefit from contacting us and have us review the case to look for the defects. You know, other than those obvious issues, this is really something that a housing attorney should look for, and we are definitely here for doing that with you. So again, the last two elements of the statutory discretionary expungement, once we have determined that there is something wrong with that underlying eviction case, we have to show that expungement is clearly in the interest of justice, and the interests of justice are not outweighed by the public's interest in knowing about the record. So you might have picked up on that similar language here. These elements definitely align with the substantial benefit and minimal harm parts in the inherent authority argument, which of course align with our big picture framework. So the second element in discretionary expungement is that the expungement is clearly in the interest of justice, which you can see here goes along with, I mean, it's basically, you know, the same thing as showing the substantial benefit part of the inherent authority. They mirror each other. That third element in statutory discretionary expungement about the interest of justice not being outweighed by the public's interest in knowing about the record goes along with that minimal disadvantage to the public part of that inherent authority argument. So on a motion form, we would start with the inherent authority argument using our big picture framework. And then if there is a defect with the original eviction case, we would also add, an explanation of the defect, and then we would just say, see paragraphs above for explanation about why this expungement is in the interest of justice and why those interests are not outweighed by the public's interest in knowing about the record. And again, a good eviction expungement motion form is going to lead you through all of these steps. And we're going to just do a quick note here on mandatory expungement. It's not something, I think I've only seen it once or twice. Minnesota statutes require expungement of eviction records where the property was subject to contract for deed cancellation or a mortgage foreclosure, and either the redemption period had expired and the tenant moved out before the eviction case started, or the tenant did not receive a notice to vacate before the eviction case started. These are pretty rare. Writing these motions is much more simple than the others. We don't have to use all of the facts and talking about, the minimal, the substantial benefit and the minimal harm stuff. We don't have to do all of that because according to the statute, it's mandatory. If we can prove these things, the judge is required to expunge that record. My advice here, if you see someone with an eviction where the property was a mortgage foreclosure or contract for deed cancellation, get legal advice, call us. We'll definitely walk you through it.
All right. Thanks, Anne. Does anyone have questions about all of the stuff that Anne was talking about? Feel free to put those in the Q&A box for sure. I know there's a lot of information for you this afternoon, but hopefully what Anne was talking about and how to write this expungement motion, thinking about the big picture and why does the tenant need this expungement, what was happening at the time, and how has the tenant situation changed to make them a safe renter. Hopefully that kind of framework is helpful. And I think that that's where advocates really shine, is being able to tell those stories. We do that when we're helping victim survivors tell their stories on a regular basis, whether it's in orders for protection, whether you're helping them talk with a landlord about, can you rent to them because they really need housing, and you're telling these stories anyway. This is just in an expungement motion form instead of talking to the landlord face to face, for example. So I think advocacy is in a really unique position to already be prepped and primed to tell this story, and having this information from Anne hopefully helps us do that on an expungement motion form to give us a new tool in our advocacy toolbox, I guess. But if it looks like there are no other questions, we'll just kind of continue on. So the next steps are about how to file an expungement motion form. And again, this is where advocacy can be really, really helpful because the process is, pretty straightforward. As always, we recommend contacting the courthouse to make sure that you're following the appropriate steps, but this is kind of the general process. So first, you'll start by completing the fee waiver form as applicable, the informa pauperis, and the expungement motion form. And once you file those, you'll file those with the court in the courthouse that the eviction happened in. Then from there, the motion form will be mailed to the plaintiff, which is the landlord. Then you file an affidavit of mailing with the court and then attend the court hearing. So again, that's extremely high level view. Definitely talk to the courthouse for sure. Everything is kind of wonky with COVID these days, especially, and some courthouses might have some quirks to how they have this filed. But I think that is a good place to start for an overview. Many of us are probably familiar with the fee waiver forms, having done them with HROs or other cases and things like that. But just in case, the link is available there for the IFP form. And you can fill this out for folks that are below poverty levels. But you can also attempt to file the fee waiver for someone who does make more money than the federal poverty guidelines. There is an expense and debt attachment that they can fill out to see if they might still qualify for the fee waiver. So you can definitely give it a shot. And again, that's where your good advocacy skills come into place. So listing exact amounts on income and cash on hand can be really helpful on that expense and debt attachment. And make sure you include everything that is counting as debt. Because if you're able to show that, yep, I might make more than the federal poverty guidelines say, but my daily living expenses or my monthly bills out are more than my monthly income, the court might be able to take that into account. So depending on the situation and what's going on, it's worth a shot, I think. Anything to add, Anne?
No, I mean, just restate it. Even if they're above that 125%, use that debt expenses and debt attachment sheet that we have on our website and make that argument, like Raelene said, because the courts will grant things that are over, or for people with income over 125% of the federal poverty guidelines, when we convince them that it's needed. And sometimes the courts will, maybe they won't waive 100%, but they'll waive it down, to 50%, something like that. So, and you can always call me too if you need help with making the argument for a fee waiver for people who are above that 125%. I'm happy to help with that.
Perfect. All right. And then, as Anne has mentioned, we have a better form. Long and short of it, we have a better form on our website to use for the eviction expungement. Most of you probably know that Minnesota courts have a lot of court forms available to the public, and the courts do have an eviction expungement form available, but definitely recommend using the Standpoint version. Remember the inherent authority expungement. This one needs to be included in all, that argument needs to be included in all eviction expungement motions. And the court forms do not have that on there. So to avoid forgetting about that inherent authority argument, use the form that we've created. The website is there. And then remember that big picture, those 3 elements that we've been talking about when filling out the eviction expungement motion. All right. So then each motion must be filed in the same court as the initial eviction case. Remember to do a MNCIS search to make sure that you get all the evictions. Again, remember that many tenants don't know that evictions have been filed in the past. So there might be some surprises there. Maybe the landlord filed more than 1 eviction and you're able to write a motion to include those. So make sure you're catching all of those evictions so that you can look at expunging all of the evictions on their record. Then contact the court clerk. Again, different courts have different processes for filing motions, especially these days. Be sure to stay in touch with that information. And then file the completed expungement motion form with the court at the same time that the fee waiver is filed. And then the court then will decide whether to grant the fee waiver before accepting the motion. And then once you have a hearing date and time, mail a copy of the completed motion form to the plaintiff, again, the landlord. The motion must include the date and time of the hearing, and then mail to the landlord using the address on file with the court. Depending on the court, you may need to contact the court clerk to schedule the hearing before filing the motion, or the court may have you file the motion first and then give you the hearing date and time. And then you'll need to complete the affidavit of service by mail, and the link to that form is available here in the PowerPoint. And I think someone asked in the questions before if we would be sending out these PowerPoints. Absolutely, you'll get all this information for sure. Then make sure that you complete the affidavit, file the completed affidavit of service with the court at least 3 days prior to the hearing, and then bring a copy of the completed affidavit of service to the hearing as well. Then the hearing. So advocates are really well prepped and primed for what preparing for any court hearing looks like, and many of those same strategies apply for an expungement motion hearing. So during COVID, definitely reach out to the court clerk to ask for instructions on how to attend. Is it going to be virtual? Is it going to be in person? Where do we go? What does this look like? Who can be there? Definitely reach out to the court clerks for more information there. After the pandemic is over, which will hopefully be someday soon, a lot of the standard court prep work that you normally do would apply. So arriving early, make sure that you're planning for extra time to find parking, putting enough money in the parking meter, helping the victim survivor think about what they're going to wear and how they're going to, make sure your phones are turned off. knowing that security is going to slow you down. So again, allowing extra time, and then making sure that the folks are prepped to be at the courthouse for a few hours, if that, that might be what it takes. The other piece to thinking about the expungement motion hearing in particular is that the judge will likely want to talk with the tenant. So you have to be prepared to show that why the tenant can be a better renter now. Again, thinking about future landlords. So that comes back with our big picture ideas. So what was happening when the eviction happened, and why and how has the tenant's life changed so that it won't happen again? This is definitely not the time to have the argument about why the person should not have been evicted. The eviction already happened. We're focusing on eviction expungement in this court hearing. Anything to add to that stuff, Anne?
Yeah, when we think about going to the eviction expungement motion, I always have the tenant kind of read through that narrative part of the eviction expungement motion that we worked on. So I remind them of what we said in the motion so that at the hearing, they say the same thing. So we don't typically want the tenant to say one thing in a motion and then go to the hearing and add a whole bunch of different facts. Unless those facts are, something new, like maybe when the tenant filed the motion, they didn't have a job, but they've since, got full-time employment. So then they would want to give that update because it's new and because it further proves, that they'll be able to pay the rent going forward. But generally speaking, we don't want to bring up new things in the hearing that we didn't really include in that motion. And again, don't try to talk to the judge about how unfair the eviction was. The judge has no power or authority to go back and relook at that for an eviction expungement. Unless we're arguing that discretionary statutory authority part where we're showing something was wrong with the underlying case. That's a very, very specific legal thing. If it's just that, a lot of times tenants feel that they weren't treated fairly, or there's bad blood between them and the landlords, and they want to complain about this at an expungement hearing, and this is not the place for that.
Perfect. All right. So after the hearing happens, after everything is done, if that eviction was expunged, you'll want to make sure that keep copies all the time. And what you'll do with those copies is send the expungement order to tenant screening agencies with a letter requesting that the agency remove the eviction record from their database. So these tenant screening agencies are the places that landlords will reach out to find out about housing histories and things like that. And if the tenant screening agency has it on their record that someone has an eviction and it wasn't expunged, it's going to continue to show up. So to help kind of mitigate some of those things, there's a link here for Law Help MN that has, I think, about 10 to 12 of the big tenant screening agencies listed. And you'll want to send that expungement order and letter to all of them so that they can get it off of their information and remove that eviction on their record. And again, just like an order for protection or harassment restraining order, you want to make sure that you keep copies. The only way to prove that an eviction was expunged is with that expungement order. So you'll want to make sure you keep it, whether you keep it in, have someone keep it in their wallet, take a picture, send it to their email, give it to their mom, wherever they keep their important paperwork. Make sure that they always keep that expungement order, because there might be a tenant agency that didn't get the order or new information is popping up. The only way to show that that eviction was expunged is with that order. So keep that for sure. Then if the eviction was not expunged, read through the order, find out why the eviction was not expunged and what the reasons are. And there may be a chance that their tenant can resolve some of those reasons later and can refile an eviction at a later time once those issues have been resolved. So read through the order, see what it says. And then definitely call Anne. Anne can help take a look and see what the order says and can help determine what those next steps might be to help the person going forward. And I think that's all I have. Anne, did you have anything to add on this piece? Otherwise, we can wrap up. Great. Does anyone have any questions or anything popping up that you've been thinking about, or has anyone tried filing an motion before, been to housing court that might have questions?
Not seeing any questions come in the chat right now.
Perfect. Well, we can definitely stick around for sure, but here is our contact information. If you'd like to reach out to us later, you can contact myself or Anne. Phone, email addresses are there. And we will definitely work on getting this PowerPoint out to folks for sure. But we're really glad that you could join us today. I'm really hopeful that we can all work together when, going forward to help folks get these evictions off their record, especially knowing that the end of the moratorium will be coming at some point. And we want to make sure that we're helping set up the victim survivors we're working for with success. So thank you all so much for being here. And
one more thing before we go.
Yeah.
At least right now, here, February 24th of 2021, we are still reviewing clients to take on for full representation for eviction expungement. So if you're working with tenants, with people, and you notice that they have an expungement on their record or an eviction on their record, refer them over to me and I'll review it. And if it looks like a case that qualifies, I might be able to provide full representation for that tenant and getting that eviction expunged.
Perfect. That's a good reminder. Absolutely. Or if you're seeing someone that has an eviction notice or anything along those lines, definitely reach out. We can talk that through. But otherwise, I think we'll let you all go for the afternoon. Feel free to reach out to us at any time.
Thank you, everyone.